But we see this kind of, and I understand juries. They go in, they sit there potentially for weeks, they work really hard, and they want something to show for it. Well, sorry, that's not how the system's supposed to work. We'd rather, 100 guilty people go free than one innocent person suffer. The system is about preserving liberty.
We are the Armed Attorneys. Today we are talking about lesser included charges in your jury charge for self-defense cases. This is inspired by the breaking not guilty verdict that just came out in the Daniel Penny matter, but important to all self-defenders because that lesser included charge can be make or break for your guilt or innocence. Before we get started, show your support for the Second Amendment by hitting the like button.
So there were two charges here, manslaughter, criminally negligent homicide. We're going to go into the logistics of all this stuff because even though Daniel found not guilty on both charges, had one case dismissed by the court, one case where he was acquitted by the jury. Incredible decision here. We have to go through the logistics of all these things, and I think the judge screwed up a little bit with a comment on the weight of the evidence. Ultimately, hey, guess what? It all turned out fine in this case. But if you are, self-defense minded, this is stuff that you have to understand because there's a lot of implications.
Oh, yeah. And I mean, justice was done in New York today, which I very rarely get to say about New York courts. But it is a wild world of lesser includeds here. So let's talk about it.
And so I think this conversation starts with, okay, we have this high profile case up in New York, two different charges there. We had a manslaughter charge. That's essentially the death of a person with recklessness. The judge has dismissed that. We got some commentary on that. And then we have this criminally negligent homicide, which is a death of a person, but with a different level of mens rea, criminal negligence. And so I think it's important to talk about, why we treat these things differently.
Right. So, we've got the general notion that you have mens rea. You have everything from intentional and knowingly, which is I meant to kill you and I took an act that intended to kill you, or I knew that it would kill you if I took this act. I did it, you're dead. To, oh my gosh, this was an accident and you're dead. Right? And then recklessness lives somewhere in between, recklessness being a conscious disregard of a substantial risk that if I took this action, you were going to die. So that is, right, I guess we'll start with Penny and we'll move on to sort of our general self-defenders here. So Penny charged with the recklessness, charged with the criminal negligence, which in New York, that criminally negligent homicide, the mental standard is that you failed to perceive the risk. Which is interesting.
Yeah, for the criminal negligence. Yeah.
Yeah, so
that's different than a lot of states, and that is wild.
It is wild. So there was a risk that if you took an action that someone would die, but you didn't even realize that risk. But not realizing that risk was a gross deviation from the ordinary standard of care. That's sort of our general criminal or gross negligence definition there.
Yeah, and I think to put it in even more plain English with an example, I like this one, the barbecue, right?
Oh, yeah, because it's a real story.
Because it's a real story. So just to demonstrate the different levels of mens rea, at the barbecue, your mortal enemy walks in, turn around, draw your firearm, shoot the person, they die. Hey, guess what? That was an intentional act, murder, okay? Because we see the physical act itself, shooting someone, them dying, all right? But then we look at the person's mind at the time. Is it intentional? All right. I think the next example, I'll just skip down to recklessness. If you are...
Well, this is the real story.
Yeah, this is the real story.
I'm going to tell you, I had a client at a family barbecue. He had a brand new holster. He was running around with the kids playing water guns. He just jostled the wrong way. Firearm fell out of the new holster. He didn't realize that just was not very secure. Went to grab it. When he grabbed it, finger through the trigger well, shot his niece, who was about 13 at the time, just through the neck and shoulder right here. She was fine. Walked out of the hospital same day, but he was actually charged with aggravated assault with a deadly weapon because they said that those acts constituted recklessness. And they made a lot of allegations. Number one, basically running around with your kids with a holstered firearm, given that you weren't really certain of the holster. Number two, reaching out to catch the gun. So there were a couple allegations there.
Yeah, but typically what we see with recklessness is there's a substantial unjustifiable risk that lives out there, and you consciously disregard it. And then, the same thing happens. Somebody gets shot, somebody dies. All right. So, but we see why we should punish these folks differently. right? Somebody intentionally tries to hurt somebody as opposed to this looks more like an accident. And that's exactly what happened in Daniel's case. The manslaughter charge carried a maximum penalty up to 15 years. The judge dismissed this during a very long jury deliberation.
Well, the state moved.
Yeah, state moved to dismiss it, and the judge ordered it dismissed. And now we're left with criminally negligent homicide, which is, I'll say their statute is crazy. And so, but that carries a maximum penalty of up to 4 years. And this discussion is important because we're talking about why we don't like lesser included charges. And then I think we can throw in some commentary about why dismissing a charge mid-deliberation with other charges pending is kind of BS.
Yes.
So,
all right, well, first let's talk lesser included.
Yep.
So this is something that happens in Texas all the time. And not just self-defense, right? You are charged with a crime, and generally it's the defense who wants lesser included charges in your jury charge, because the defense attorney says, well, they might not, if it's just all or nothing on this possession of this amount of drugs, my client's getting convicted because he's a bad guy and the jury's not going to like him. But maybe I could talk him into one of these lesser includeds. Maybe we cut the manufactured delivery, maybe whatever they think is their best avenue to get their client less time. The jury still gets to punish the guy they don't like, but you don't hit that top level. Super makes sense. So most of the time, it's actually the government fighting against including lesser included offenses. Self-defense turns the world on its head.
Yeah.
Because the defense team generally does not want anything other than that highest level charge you've been charged with in that jury charge. Why? Well, someone's dead.
Yeah.
Right?
No, exactly right. And so, you have this reduced punishment issue. And I think a question a lot of folks have, they say, hey, isn't this double jeopardy? Like you're charging this person. And the technical answer is, well, it's not the same offense. And what courts look at is, hey, do these offensive do they have different elements? And if it has one element that's different, but it covers the same conduct, we see courts say, guess what? Double jeopardy, that does not invoke. You can proceed on both of these things. The legislature obviously intended for, all of these different things to be criminally prosecuted. And so for the difference between the manslaughter and the criminally negligent homicide, we changed the mens rea, different elements, not double jeopardy.
Right.
And so, but going back to this all or nothing issue, I think, why do we want the all or nothing issue? It's because if you're justified at the highest level, why wouldn't you be justified against all these other ones?
Well, for me, it's because, I said it earlier, someone's dead.
Right.
That's the problem, is that, yes, you are justified for everything. However, juries have this soft spot a lot of times. You've got, sympathetic, like, gosh, that last murder that Leslie and I tried where the guy's wife got up on the stand and cried and cried and cried and cried and cried. And, he was made to be very sympathetic, despite the fact that he really was not a particularly good human being.
Sure.
But juries, they look at that and they're like, gosh, someone's dead. I see self-defense facts. I don't want to convict that guy of murder because I know he was defending himself. But maybe the fact that a life was lost, some justice must be done. I will convict him of manslaughter. Right. And we don't want that. It needs to be all or nothing, black or white. Just like Richard said, you're justified for one, you're justified for all. And we don't give the jury the chance to kind of split the baby because, you understand that kind of soft human part of them, but that's not what we do.
Right. And it makes sense, right? This doesn't make sense to me. You're going to say, hey, it was justified in, taking this other person's life because it was reasonable and immediately necessary for this one charge. Okay, same facts, different elements. How could it not be justified under those circumstances? But we see this kind of, and I understand juries. They go in, they sit there potentially for weeks, they work really hard, and they want something to show for it. Well, sorry, that's not how the system's supposed to work. We'd rather, 100 guilty people go free than one innocent person suffer. The system is about preserving liberty, and so I think for that reason, you got to cut these things loose.
You got to cut these things loose. So, why does it matter that the state moved to dismiss part of Daniel Penny's charge and not the other part? Well, it makes, first of all, it's wild to me that they charge, right, he's not even charged with murder, right? He is charged with, at best, being reckless And then the government looked at it and looked at the jury questions that came out and said, they're not going to convict him of this. And I think their calculation was, we look like we don't know what we're doing because we can't get him on the top one. And if we can't get him on the top one, maybe the jury's going to think we just totally screwed up in bringing the charge. But if we go ahead and withdraw this one, they're going to think they have to convict on that one.
Yeah.
I think that's what happened.
Well, and the two things that kind of drive me nuts about this are the way that New York defines criminal negligence, and then this is an improper comment on the weight of the evidence. And we'll talk about both of those. But if you look at the way New York defines criminal negligence, they are criminally negligent homicide. What they say is, you failed to perceive the danger or the risk. Whereas most states say you should have been aware of the risk. Right. And I know those sound very similar.
Ought to have known.
Ought to have known, but this is, you failed to perceive something and then something bad happened. That seems wrong.
Yeah. I mean, because imagine in this particular case, right? We have had other high profile cases in which someone is high on drugs and then restrained and then death occurs. And so what is the fail to perceive here? If you fail to perceive that he's high on drugs, well then, maybe that's enough, right? Well, you shouldn't restrain someone who's high on drugs because, there's all sorts of weird circulatory and breath issues that can then result in death if you are messing with their body. Well, is that enough?
Well, compare that to other states that just say you should have known. Well, if this person is manifesting stuff or saying things, well, then you see, all right, those are two different standards. This seems even lower. I feel like they should call it something other than criminally negligent homicide.
It does feel lower.
Yeah. So, and then I want to talk about this dismissing. The state obviously moved to dismiss. Court granted it. Mid deliberation, typically we prohibit courts from commenting on the weight of the evidence. This seems like a comment on the weight of the evidence.
It does. And the judge had to go back and clean it up. And the way that the judge sort of dealt with it was like, okay, this is dismissed. Now, move on, towards count. Well, I forgot exactly what he said, but it was like, all right, now, you're marching forward with count 2.
Right.
It's like, what? And then he had to go back and say, well, I didn't mean that you have to convict on count 2. I just meant that's what's left for you. And it really did feel like there was an improper commentary. I mean, the fact that one is dismissed, period, feels bad. But then the way that he did it was really kind of icky.
Right. And we prohibit judges from commenting on the weight of the evidence because guess what? They're so influential in these trials. They're there to theoretically call balls and strikes. The jury has the facts. The court gives them the law. They smash those two things together, as I like to say, and come up with a verdict. But when the judge starts commenting on the weight of the evidence, okay, now they're stepping out of their purview. Maybe you don't get a fair trial.
Right, because the judge is supposed to be neutral.
Yeah.
Right? I mean, state fights hard, defense fights hard. Juries understand that they are both biased to their sides. But once that neutral arbiter starts kind of leaning one way, it really does influence the jury. And I mean, Richard and I have both had bad judges who did that regularly in trial, and it makes a huge difference. The jury says, the judge is really getting pretty short and snippy and making a lot of weird sidebar comments to the defense attorney. Probably means the defense is doing something really bad. I think I'll go with the state.
Yeah, and that's why judges, juries can ask questions. Doesn't mean they're going to get an answer, and you see this. And this happens all the time. Juries ask a lot of questions, and sometimes they get answers, but we have a ton of great judges, and this is the response that they receive. You have all the evidence before you. Please continue your deliberations. Perfect. No comment. Not putting their thumb on the scale, just telling the jury to get back to work. That's the kind of stuff that we would hope to see, but man, this just doesn't feel right.
It doesn't feel right. So
yeah, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question and comment for us below. If you were on trial for a big self-defense case, would you want those lesser included in just in case? Until next time, we're the arms attorneys.